of 650% are before the arbitrator, and he takes into consideration ignoring the fact that they had received. So once what I trying to advance my submission is you have. So my submission would be that there was no occasion for them to, and rightly they did. Once they have received the entire compensation, where was the occasion for them to agitate any issue? So they remain silent. They remain silent. But when they found the fence sitters that the 20 persons have been given the chance before the arbitrator who had not received it, so they joined the wagon and said that no, our case we also consider for the purpose. My lord is in land acquisition.
I just wanted to see.
Yes. So it says that judgment which I like that it is a self-contained code and we cannot go into the terms and the determination mode of land acquisition.
26, 28A also will not apply.
Not apply.
That any other person's enhancement has been done, so that will not be a basis for enhancement of compensation.
Purpose, my lord, your leadership will find that the requisition is in urgency concern, and I have taken your land in requisition for a purpose of union, and I am paying for that. Now I think that it is required for me permanent, so I want to compensate you. So date of acquisition, I will determine the market value. But you cannot say, because it was in my occupation for last possession for last 30 years. So what all I did on the land, it was an improvisation at my cost, my investment. Now tomorrow you cannot come forward. What evidence there will be? Bagal mein bahut bada building. So just evidence wala claimant witness number 1. That is part of the claimant exhibit, first page itself. I am placing 2-3 paragraphs.
The very fact that the present status on the date of it being acquired has not been taken into consideration. According to you, the reason is that there could be a number of things which might have come up on the property.
I go down. Exactly, this is my submission.
Buildings.
There may be road, 41 there was nothing.
No, there may be, suppose a multi-story building comes up and it is his property. So the valuation cannot be done land and building.
Yes. No, land and building, and because of they say that it has attracted that now it is close to city. Now we have to take into consideration 41 status. City has expanded.
The nature of the land is there, but the date of acquisition is
market value of date of acquisition.
So market value of date of acquisition. If you take the market value of date of acquisition,
of agricultural land.
No, whatever it is.
Yes. Because it's a condition of the land.
Condition of the land. Let's take it. It was agricultural.
Yes, they admit it. Their evidence.
Okay, let's take it that it was agricultural land, right? It was taken. Now the market value
of the agricultural land.
Of the agricultural land on the date
of
acquisition.
Yes.
Therefore, the location position will have to be seen on the date of acquisition.
Yes, but with
you can't have both the things.
No. I am submitting.
And then the market value of the land on the date of acquisition, that is 71. Whatever be the surrounding value of the land, even if agricultural land is by the side of a national highway, then the value could be much higher.
For your leadership, this rate is being determined by the state government, by the state, and agricultural land. This is admitted fact. I would say that they determine the rate of agricultural land, Dhani 1, Dhani 2. This is
based on what?
Productivity.
No, not that is not the report. That is not the report. We will not assume. You see, the report is referring to certain salients of that particular area or whatever. Those salients are not exhibited.
The report is not essayed by them.
Need not be. You have to prove your case. They have to prove their own case.
The report we have not examined.
What prevented you to produce the salients of that particular salients which have been referred to in the report?
I am putting a question to myself. This my document exhibit 10 is marked as an exhibit.
Document, no, that is
exhibit and it is marked without objection.
You see, that is absolutely under cloud. Right? That is absolutely under cloud.
And exhibit 10, they have produced it.
Whosoever has produced it, whosoever, it is your document.
But they have produced.
Whosoever has produced
can
it, how does that make? No.
This will be my submission. Subject to my lord's appreciation. This will be my submission that they have produced it.
We have to see on the basis of whatever salients and documents have been produced. That particular 10 by itself will not quantify the compensation. No. If you wanted to stick to that particular computation, then whatever was the basis which was there at the time of computation by the land acquisition officer, that should have been placed before the court. That in the year 1970-71, this was the rate of the land.
So in first appeal, we are in a situation that Exhibit 10, relied upon by them, they have produced this document, and we have failed to bring on record any sale deed, and the arbitrator has not taken any document of 71 for determining.
Only
So,
one. Only
no,
one
he has not
document.
taken into consideration.
He has taken into consideration.
71 document he has not taken.
He has. Of course he has.
Marked exhibit, but what he has done, he has taken 62, 63.
No, you just have a look at it,
Yes.
what he has done. We had so much of discussion yesterday on this.
It's just
You just see the computation. Come to internal page 30,
yes.
right? He takes the average of exhibit 5, exhibit 7, exhibit 8 and exhibit 9.
So he takes all.
Just a moment.
Yes.
He takes the average of all 5, 7, 8 and 9. Correct? And there is one document over here, that is exhibit number,
9. That is 9. When your addition 71.
yes, exhibit number 9. Correct?
Yes.
Exhibit number 9 is a sale deed or dated 2471.
So he.
So he has a document, he has a sale deed of 71, which he has taken into consideration, but by considering it, he has taken average by other methods which he has come. So what I was pointing out yesterday, that if there is even one evidence, there is no occasion to take average and refer to other documents. This was
Yes,
what
yes,
I was
exactly.
referring to,
Yes,
this is what I want them
yes,
to answer.
exactly.
So you cannot say that before the arbitrator there is no sale deed of the year 1970. There is a sale deed of the year 1970.
Yes. But we are saying that.
And your officer also took same rate for all the villages. Correct? 6,000 dhani.
Yes,
Is there for all the villages, uniformly he has taken.
Yes, yes.
So there is no doubt
But
about
for
the
different class of
uniformity.
land, he has taken different rates.
That's right. So far as the uniformity is concerned, there is no doubt.
No doubt.
There should be classes, that is another.
Yes.
That is your contention. Now, so far as exhibit 9 is concerned, so far as different classes of land are concerned, what is the evidence on record?
No, they do not say this part of their.
What?
They were before arbitrator.
We will
They
not
say
suit them before
Okay.
because of this. The entire computation was under challenge.
no. They don't say that this was not different class of land. I will read their evidence just for a moment.
No.
So why all the
No,
class
no.
of land will be classified as
No,
dhani bar?
just and fair compensation is to be seen. You tell us what is the mode of computation for Dhani 1, Dhani 2, etc.
That
What is the mode of computation?
If your ladyship, I can produce that document. It is from the state is
No,
having
we
the
will
report
not-
from.
we will not
agriculture.
want that.
So it is their document. They do not assess the report. They do not deny the fact that there are different classes of land, of agricultural land, and their evidence. Just for a moment, if I place oral evidence, what they have used on the point. Oral evidence. First page of their affidavit. If I place 2-3 paragraphs. Witness Virender Math.
And at the end of the day, we should not forget that this is an arbitral award.
But not in the scope of arbitration.
That's right.
And we are in first appeal, not in objection under 34. So we will assail every aspect because this is the last court of fact. When you are in first appeal, this is the last court of fact. We have to look into the fact aspect also. So para 2, if I place, यह कि चारों गांवों की जमीन, this is their chief, एक जैसा है तथा गैर कृषि योग्य है, गैर कृषि योग्य, तथा सन 71 में खुली बाजार बिक्री मूल्य 2 लाख रुपए प्रति एकड़ से अधिक की थी, क्योंकि सभी तरह की जमीन मकान बनाने योग्य था। ये चारों जमीन राष्ट्रीय राजपथ बगल में स्थित थी। जमीनों का मूल्य काफी ऊंची है। नाउ व्हाट इज इन क्रॉस एग्जामिनेशन दैट इज आंसर? Yes, question number 19 in cross examination, that will be internal page 9 of this agreement. Question number 19. Responding yes.
Question number 19.
Yes. What crops you were cultivating at the time of acquisition in the year 1971? He says, I used to grow 4 times in a year and used to grow paddy, madwa, arhar, sakartan, urad, only, wheat, etc. So he admits that it is agricultural land in the year 1971. And then what he says, and then question number 23 also we see. Are you claiming compensation on the basis of
22 also we should claim.
Yes, yes. 22 also. Whether
Through the village. It passes through the village.
1911 NS32 was also there, which connects Purulia and passes through the village Lalganj.
So that
That
NH was always there.
Yes, but having taken that fact, the nature condition of the land will be still ascertained to be an agricultural land if I confine to it. Then
Nature and condition. So while figuring out the nature and condition of the land, you want to say that that it being adjoining to national highway is not to be taken into consideration.
productivity and cost of the crop. Suppose in say 41 is the cost of the crop.
So therefore you want to say that if the property is in the midst of the town and is otherwise agricultural land, and if a property is in remote village, Ranchi hai aur ek Gundru Fall, right? It will have the
That
same
is how
value.
legislature has said.
No, we will interpret it.
Yes, that is
We
their value.
cannot go to such an
I am bound by the
absurdity.
legislative intent and
Yes.
purport, and law
Your
is
intent.
unambiguous. So golden rule of interpretation will come.
When we see the nature of land, the nature of land will cover all surroundings, the location, the position, the availability of water, the availability of sunlight, the nature of soil, and many things. You just cannot confine it to 4 walls that this particular land has been classified as agricultural. So it is irrespective whether it is next to the national highway or it is deep inside the village, the value would be the same.
My
that's why
submission,
chalega.
my submission, I am always submissive before my lord. It is up to
No,
leadership to interpret.
does it sound to your
That is how
good
legislature,
conscience?
and that is that judgment I said that it has to be seen in the background of the fact that
No,
1952.
the interpretation that you are suggesting will lead to this kind of situation.
But what I am submitting, let's just have an appreciation. This law came into existence when right to property remained a fundamental right in this constitution. 1952. So legislating and law is so unambiguous in its expression that what will help them is that the crop value of 41 may be 10 rupees per quintal. Now it is 1000 rupees per quintal. So the productivity vis-a-vis the market price, and then the computation process is there to determine their compensation. Highway will not help them. They cannot convert the agricultural land into a multiplex and say that now what they have said in examination in chief, that we could have developed there exist multi-storied buildings.
The
And
entire position of the land has also been mentioned in question number 20. Right? You just see the
Yes.
how
Was there
how
any
well
activity
located.
going on other than cultivation over the land in question? Land in question, he says, towards east of village Sugnu and Lalganj factory of Usha Martin, the electrical equipment of so and so were situated. Towards this office is situated. Towards south there is animal husbandry government and Khelgaon is situated. On the western side NS 33 so and so. Petrol pump and market are also situated. Khelgaon, I am putting a question to myself. We are at least consciously aware Khelgaon kab bana. He has not said, he is giving the present status of the land. He is not revealing the status of 1971.
You see, at least for our general knowledge, we know that this BIT is much older than 71,
Yes,
right?
yes, yes.
Usha Martin is much older than 71. This electric equipment factory is also much older than 71. FCI Godown is also much older than 71. We have all grown up in Ranchi, so we know. If we see,
I cannot doubt that because I personally cannot have that.
we
issue.
cannot
I have
shut
no
our
right to
eyes
live there.
that this BIT is older than 71.
Yes. So how BIT will fetch good price because it is a hostel facility of
No,
educational
no,
institution.
that is a separate thing.
No, no.
Whatever he is saying, maybe
Yes,
that
I-
Khelgaon has come up recently. We do not know. Khelgaon might have been acquired much earlier. We do not know. The property must have been acquired much earlier. It has been developed now.
That will go in assumption, your tradition. What material was before the arbitrator? That is the good question we have
No,
to say.
your contention that only the nature of the land is to be seen and the position, location, and to determine its market value
On the date of acquisition.
on the date of acquisition. So if the market value is to be seen on the date of acquisition, then the market value will certainly depend upon the location of the property, be it agricultural or non-agricultural. If in the midst of a city there is an agricultural plot, its value would be much, much higher than the agricultural plot which is situated away from the town.
If that is taken, then one more aspect, whether nature of the land was sellable or non-sellable, we don't know. We don't know. And if it is non-sellable, it cannot fetch
So
any
there
higher
should
price.
be a zero price for that.
No, that is what they have determined on based of productivity. Because non-sellable
No,
land,
from where do you say that they have determined on the basis of productivity?
that is
What is
by-
the material?
That is by report, that I cannot go beyond that, and report is not asset, and it is their exhibit.
Report, they have not mentioned about the productivity of the plot.
If I just place the your relation, certain part of the report that was plain. If I place the report, 2-3 pages are released. Just quickly place it.
Exhibit 10.
Exhibit 10, after the order sheet. This is a case for acquisition of land in village Lalganj.
Yes.
Your leadership is there.
Hmm.
This is a case for acquisition of land in village Lalganj for Defence Department under RAIP Act. It was requisition under the Defence of India rules, white case number 6 of 1941-42 for 612.53 acres. Military State Officer Bihar and Orissa Circle, Dinapur, while his letter number so and so, intimated that government's decision to acquire the said land permanently. Notices in I form under RAIP Act were published locally and served to a person interested by notice number so and so dated 28/8/71 and 23/8/71. Some 19 objection petitions were filed in pursuance of publication of RA forms locally and services of notices on persons interested. These objectors were heard and orders was passed. After that, notices in J form of the RAIP Act was published in the Bihar Gazette in Part 2, dated to 2556 of 29/11/72. A thorough Gujarat was done after the publication of J form, and it was found that there is a discrepancy of 0.10 acres in plot number 961. Accordingly, J form and valuation Khatiyar, the plot measures 0.35 acres, whereas per record of the right measures only 0.25 acre. As such, payment can be made only for 0.25 acres In Gujarat area and classification of land comes as follows: Dhan 1, 67.61 acre, Dhan 2, 86.40 acre, Dhan 3, 61.52 acres, Dhan 14.70 acre, Dhan 2, 275.64 acres, Dhan 3, 20.91 acres, Parti Rahiti 69.51 acres, Vyar Mazurwa Am 6.69 acres, District Board 4.77 acres. Government land 5.0 acre, total 612.43 acres. Sales figures for consecutive 3 years were collected to assess the valuation of the land under acquisition. Altogether, only 4 sales would be found during the stretch of 3 years. 3 sales relating to serial number 1 to 3 are far away from the land under the acquisition, and they do not agree in situational advantage facility with the lands under acquisition. Serial number 4 relates to the same mixed classes of land under acquisition. As such, no sale will be help us in arriving the assessment of valuation of land under acquisition. The village Lalganj is a contiguous village, and Khatanga land of this village have also been acquired for defense purposes by notification number so and so of 7071 and a case number 2 of 1970-71 respectively. The rates of different classes of land of these villages have been approved by Deputy Commissioner Ranchi as follows: Dhan 1 6,000 per acre, Dhan 2 4,800, Dhan 3 3,000, Dhan 1 2,400, Dhan 2 1,200, Dhan 3 300, Parti Rahiti Vyar Mazurwa Am 225. As such, I suggest that the same above rates will kindly be approved for payment of compensation for different classes of land village Lalganj, also as the land of these villages agree in situational and fertility with the lands of villages Dumardaga and Khatanga, which were acquired for the same purpose. Valuation of trees as assessed according to government's instruction comes to rupees 26,724, which was may kindly be approved. The military state officer is of the view that trees, the girth of which is below 3 feet, have grown up after requisition. As such, payment relating to these trees will not be made to the Raiya. Trees which are beyond 3 feet girth were standing at the time of requisition. Also, as such, the assessment of valuation of these trees have been made. There are 68 houses in the land under acquisition. As such, schedule of houses is being sent to Executive Engineer PWD for valuation. Provisionally, ₹1,36,000 have been provided in the estimate. Payment of houses will be made after assessment is received by the Executive Engineer PWD Ranchi. There are 112 Pakka and 15 Kacha walls in the land under acquisition of ₹3,000 has been provided in the estimate, but payment of to owner will be made after the assessment is received from the Executive Engineer PWD Ranchi. 20 years capitalized value of rent will be deposited under Head 9 LR4 landlord's interest. The rates have been assessed in consultation with the Special Military State Officer Ranchi, submitted Deputy Commissioner through so and so. Then it is there.
Where is it mentioned that the productivity of the land has
So no, that is a rate that is approved. That is rate is quoted 6,4,800. So it says that because land sale deeds are of very less, 3-4 number, and that cannot be because of they are not in contiguity. So we are taking these rates, and this rate they have not.
Rate of different assessment. You see, he refers to the rate of another which has already been approved by the Deputy Commissioner.
Yes.
Where is that document? And what was the basis of fixation of the rate? From where do you say that the productivity of the land was taken into consideration? From where do you say this?
This is the document. Now my submission would be that where the arbitrator has dealt with this issue, that you have not produced the productivity or the rate chart.
Need not.
So he cannot substitute.
You see, none of you have produced any document regarding the productivity of the land. Rather, they have stated that productivity was rupees 27,000. Some statement is there. No. Produce.
25,000 basically.
25,000 or 27,000 they have said.
Anyway,
Right.
figure will.
Yes, whatever be the figure. They have given a figure that this was the productivity. But this particular document is simply adopting the rate of a different land altogether. And we do not know whether this particular rate, whatever was in which land it was applied, and whether this particular acquisition, the rate was finalized, not finalized. We do not know anything about it. This particular assessment says that none of the sale is produced can be taken into consideration.
4 sale dates because it is
Whatever.
so the reason has been assigned.
Reason has been assigned, right? Had any of these sale deeds produced before the authority would have taken that sale deed into consideration. Now, before the arbitrator, we have a sale deed.
But he has not assigned any reason why not to go into this aspect that we cannot say that it is a.
We are
he
not.
says that he
Arbitrator was not sitting in appeal against this. Arbitrator was not the appellate.
He was a statutory authority under the Act.
That's right, to determine the fair compensation.
So he must have travelled through the Act.
He will travel. He will not scrutinize as to what he has done. This authority has done. Rather, he will assess the valuation of the land on the basis of whatever materials are produced.
So on that point, therefore, I had to advance my submission. It is their exhibit. They have not asserted this.
And here also nothing has been mentioned. No reference has been made regarding the productivity.
An arbitrator nowhere has said that this document I am not to rely. He says the valuation is contradictory from where he derives it. But anyway, this is the only document which is on record.
And this particular document, Exhibit 10, is not referring to anything more. What is it referring to?
Then Deputy Commissioner, if your leadership will come down the line. For different villages, he has taken this. For different villages, these areas are taken and rates are taken. Rates are because entire area, the productivity, because land itself was classified into various categories. So, to maintain the parity, your leadership will find that more or less it is running in the same range. So, that is whole report. And that is my submission. It's up to your leadership to decide the issue. Now, I will be coming. So I am concluding my argument on the point of valuation. Yes. So I am concluding my argument by summing up the issue on this point of quantum that Exhibit 10 produced by the claimant has never been assailed. They have come up with an enhancement of compensation. Now the point remains that arbitrator, while dealing with the issue, has totally ignored my Exhibit 10, has not written any finding on Exhibit 10, and he has come up with his own finding on the point of compensation, which in my summation, he was more or less guided by the nature of the land in 71, taking all extraneous things which was there not on record. That is not part of there. Some statement has come, but when these all things come, so he cannot substitute with his own understanding. Something must be there in material on record. This is my summation on point of. There is one sale date which already I have placed, that is 71. Now I leave it to leadership on the point of quantum of compensation. Now I am coming to the issue of award of interest after the award.
The sale deed which is placed on record is Exhibit
9.
9.
9 is one. He has taken 4 sale deed, averaging it, but your leadership has taken that it is at least one sale deed of 71 which can be looked into. Rest are of 62 or 86, and he has given a forward calculation and reversal calculation. So the gap is so high, he comes to a 42,000, 6,000 to 42,000. Even if I take that all land at the same rate, it is 700% increase. One judgment. Now I am coming after this quantum that I have summed up. Yeah, the 2010-3 SEC 673. 2010-3 SEC 673. क्या बात है हम लोग इस आखिरी के origin है. Your leadership, may kindly come to para 4. I am addressing the issue of interest. Now, because learned arbitrator has granted 9% interest during the till the award and 15% after award.
9% till award.
Till award and 15% after the date fixed cut-off date for making payment. Thereafter 15%. Yes,
Yes.
Small judgment valid 2010-3 SEC, para 4 onwards. The arbitral tribunal passed an award in favor of the respondent, directing Union of India to pay a compensation of rupees 2,000 per decimal of land and solution of at the rate of 20% and interest at the rate of 9% per annum on the balance amount payable to the respondent. The arbitral tribunal further directed that amount payable to the respondent shall be paid within a period of 3 months from the date of passing of it, failing which Union of India shall pay an interest at the rate of 12% per annum. The High Court, by its order dated 27/4/2007, while upholding the award of the arbitral tribunal, reduced the post-award interest from 12% to 9% per annum. The High Court, however, directed that if the amount is not paid within a period of 3 months from the date of order, the respondent will become entitled to post-award interest at the rate of 12% per annum. The limit of 3 months to execute the award was extended by the High Court by another 2 months. Agreed by the said order of the High Court, the Union of India filed a special leave petition before this court, which was dismissed on the ground of delay. The respondent filed a contempt petition before the High Court of Jharkhand, Ranchi, alleging that the appellants have not complied with the award passed by the arbitral tribunal and upheld by the High Court where its order did so and so. The High Court, by the impugned order, has directed the appellant Union of India to calculate and pay the interest at the rate of 12% per annum from 22/6/2003 to 25/11/2006 on the amount of so and so. Agreed by the aforesaid order passed by the High Court in contempt petition, the Union of India has filed the appeal in special leave. The learned counsel for the respondent submit that respondent are entitled to interest at the rate of 12% per annum on the awarded amount, solution, and also amount of interest as directed by the High Court, as the appellant have failed to make payment within the time granted by the High Court. The learned counsel for the appellant submits that the respondents are entitled to the awarded amount and solution with interest at the rate of 9% per annum. She further submits that the whole amount has been paid by the appellant and a copy of the compliance report is given. This court in Union of India vs. Choduna has clearly laid down that landowner under Land Acquisition Act vis-a-vis RAIP Act or Defence of India Act are not similarly situated, and solution and interest on the amount of compensations are not legally sustainable. We are of the considered view that payment of interest at the rate of 12% per annum from so and so on the amount of so and so amounts to payment of interest on interest, which is not permissible under RAIP Act. Consequently, the impugned order of the High Court is set aside, which is allowed in contempt petition filed by the respondent before the High Court. This appeal is accordingly allowed. Now, principle, that is a constitutional bench judgment, will be placing. This is 2003-5 SCC 568. Union of India vs. Jharkhand. 2003. There are 16 onwards. Actually, para 14 if we start. Para 14 the said act was enacted to provide for a special measure to ensure public safety and interest, the defense of India and civil defense and trial of certain offences matters connected with Chapter 5 of the said Act provides for requisition and acquisition of immovable property. Section 23 of the Act, which begins with a non-obstantive clause, enables the central government or the state government, as the case may be, to requisition immovable property and make such further orders if in the opinion it is expedient so to do, inter alia for ensuring defense of India and purpose and grafted therein. Section 24 of the Act entitles the owner of the property to receive compensation on the requisitioning of the property. The determination thereof is required to be made upon taking into consideration the factors enumerated therein. I will be now coming. I will request your leadership to kindly come to para 16 only. The said Act is itself self-contained. It lays down a procedure as well as machinery for determining the amount of compensation. It is not in dispute that the provisions for payment of compensation under the Land Acquisition Act would not ipso facto apply to the acquisition made under this said Act. The provisions of the two acts do not provide for the same scheme for acquisition. In Hari Krishan Khosla, a bench of 3 judges of this court, while considering the provisions of Requisition and Acquisition Act of Immovable Property Act, clearly held that the provisions for grant of solution and interest under Land Acquisition Act cannot be read into the provisions of the same Act. Having regard to the provisions of Section 8(3) of the 1952 Act, this court opined that the provisions thereof should be aimed at giving landowner just compensation on the acquisition of this land, whereas under Land Acquisition Act, lands can be acquired in terms of the doctrine of eminent domain so long as there exists underlying purpose therefore, and in the view of the matter, the factor determination of compensation thereunder need not be similar. Then in Dhanvanti Devi's case, the question thereof therefore emerges whether it is necessary for the state legislature to expressly specify the interest or spoliation shall not be payable for the lands and property under section 7(1) of the Act. Sub silentio is eloquent. It would further be seen that section 8 of Central Act equally does not provide for payment of spoliation and interest. The Act was passed in the year 1968, while Central Act was passed in 1952. It would therefore be reasonable to conclude that the state legislature was cognizant of the express provision for payment of interest available in the Acquisition Act. The Act omitted similar provisions for payment of interest and solution as part of the component of compensation, obviously to fall in line with the Central Act. In first Nagpur improvement case, the question which arose therein was whether the state government being the acquiring authority for the acquisition of land, be it under the Improvement Trust Act or Nagpur Urban Development Act or Land Acquisition Act, any discrimination can be made as regard to the formulation of different principles of compensation, and such classification would be violative of Article 14 of the Constitution of India. It was held it is equally immaterial whether it is one acquisition act or another acquisition act under which the land is acquired, if the existence of two acts would enable the state to give one owner different treatment from other equally situated, the owner who is discriminated can claim protection of Article 14. Secretary Chief Justice, speaking for the bench, however, observed that the state can make a reasonable classification for the purpose of legislation. The learned Chief Justice held that the classification, in order to be reasonable, must satisfy two tests. The classification must be founded on intelligible differentia, and the differentia must be rational relation with the object sought to be achieved by the legislation in question. However, he hastened to add that object, therefore, itself must be lawful and cannot be discriminated. The court in Second Nagpur Improvement Trust came to the conclusion.
What do you want to read it? You are reading the entire judgment.
No, paragraph 27. Paragraph 27. Then paragraph 35 is straight away. Conclusion.
You read paragraph 27 also?
27.
It's a short paragraph.
One of the principles for determination of the amount of compensation for acquisition of land would be willingness of an informed buyer to offer a price thereof. In terms of the provision of the said Act, acquisition of the property would be in relation to the property which has been under requisition during the period the owner of the land would remain out of possession. The government during the period of acquisition would be in possession and full enjoyment of the property. That 28 also. It is beyond any cavil that the price of the land which a willing and informed buyer would offer would be different in the cases where the owner is in possession and enjoyment of the property, and in the case where he is not. The formulation of the criteria for payment of compensation in terms of which cannot be said to be arbitrary and unreasonable. Parliament, while making the provisions for payment of compensation, must have also taken into consideration the fact that owner of the property would have received compensation for remaining out of possession during the period when the property was under acquisition. Then paragraph 30 also may present. We are therefore of the opinion that classification sought to be made for determination of the amount of compensation for acquisition of the land under the said Act. Land Acquisition Act is reasonable and valid one. The said classification is founded on intelligible differentia and has a rational relation with the object sought to be achieved by the legislation in question. It may be true that in Haji Muhammad case, this court observed that considering the provisions of Defence of India and the principles on which compensation was to be ascertained under 19 of the Defence of India Act were the same as those provided in section 23 of Land Acquisition Act. Even the principles of ascertaining the amount of compensation as it is stood did not provide for payment of solution. The said decision, however, having regard to the provision contained in 31 of the Act, which lays down criteria for determination of the amount of compensation, cannot be said to have any application whatsoever in the instant case. Now, paragraph 35. The question, however, which remains for consideration as to whether the amount of solution and interest which the applicant has paid to the respondent should be directed to be refunded, we think not. Even in Hare Krishna Koshala, this is the case in which 16 years no arbitrator was appointed we think it is just and proper to apply principles laid down in Harbans Singh. This court held as under having regard to the peculiar facts and circumstances of the present case, and particularly in view of the fact that appointment of the arbitrator was not made by the Union of India for a period of 16 years, we think this is a fit case for solution at the rate of 30% of the amount of compensation and interest at the rate of 9% to be awarded.
Would you go by peculiar facts and circumstances?
Last, it says that in this case also it says that para 37.
You read para 36 also.
Third, yes, then let me conclude it. In this case also it did not. It is said that arbitrators have not yet been appointed despite repeated. Your leadership will take it to know. Appointed despite the demand made by the in this behalf by the respondent. The amount of solution at the rate of 15% per annum and the interest thereupon had been paid in early 80s when Punjab and Haryana High Court declared the said act ultra virus Article 14 of Constitution of India. In the peculiar situation of peculiar fact situation obtaining in this case, and in as such the amount sought to be recovered are small, which are paid to the respondent decades back. We are of the opinion that interest of justice shall be met if the applicants are directed.
The refund was rejected.
Yeah, but then last line. However, we hasten to add that this direction shall not be treated as precedent. So two things emerges out from this. This is a constitutional bench judgment, 5 judges. So it says that solution, the act is clear, interest act is clear. Now here was a case when this solution was paid and recovery was said because the amount involved was small and decade back it was paid. And repeated demand of the respondent was there for appointment of arbitrator. Our case is that they received the amount and there was no occasion for them to come for an arbitration. They remained 16 years silent, then in 91 for the first time they come and we never delayed the things. From 91, things we availed the legal forums, then in the midst one of the learned arbitrator passed away and then arbitration we have participated. So the award of interest and solution is overburdening and it is something which is travelling beyond the scope of the act. And as has been held by the Honorable Apex Court, that Parliament was conscious of the fact and it cannot be taken perimeteria with the other act because there is intelligible differentia, object is very well ascertained in that. So taking into consideration this fact, award of solution and interest in the present fact of the case.
What should have been the interest? No interest.
That is what post award interest, it is said nothing. It is an interest on the other judgment which I said.
No. For this, as per the provision of that, is there any statutory interest?
No. Interest and solution, there is nothing in that.
No interest.
No, that is what if I just place the judgment again, that 2 line it says, and clearly this judgment has dealt. No interest, no solution is prescribed, so you cannot award it. And there was a case where it was awarded because they approached at the earliest point of time. Here my case is that since they have received the entire amount, there was no occasion, and 16 persons who received under protest 20%. Yes, sir. Yes. This is on the point of interest and solution.
Even those 20 persons, according to you, they also received the compensation or they did not receive the compensation?
That some columns are blank, but again I will say, I have asked my state officer to bring that report. They will be in better position to say that who all have received and what they, because from their claim statement, things will be clear. What is their case before them. That we could not get from the report. But I asked my associate to again today inspect the record and we get the claim and our report. But that 20% from the writ petition, they can be identified and we take it there. Because for that 20 we agreed from day one for arbitration. The dispute only arose when the notification
There are
was
writ petitioners in WPC number.
the full CWJC number and just it is CWJC number 1590 of 91 R 2257 of the 91 R 2242 of 91 R and 2252 of the 91 R. That is reflected in para 3 of the award itself. Para 3 of the award we will show you this. And then in Supreme Court also they say that if they are representative capacities, the honorable apex courts are very well because who are illiterate drivers, they could not travel down, so let them be before the forum. Why adjudication? And this is how the maintainability, now this aspect of maintainability has, if, how the issue number one, maintainability has been dealt. Your ladies will find, since the Supreme Court has said, so I have to decide it.
No, it has not been dealt in that manner. Rather, the court says that since the agreement has not been entered into, it
With
cannot be
anyone.
said.
With anyone. With
It's the
anyone.
fact that
Okay.
it has not been entered into with anyone. It is an admitted fact.
Yes, agreement has not been entered, but they have received the entire amount.
They have received the entire amount.
This is our case.
And 20 of them, you can say at best, can be
Yes.
said to have not.
So for
happened.
delay, we cannot be held liable. Standard argument will be in 91, one who has received the entire amount, joining the wagon in 91, 93, and saying that I have delayed in their payment. The whole payment has been due, subject to correction only because what I could gather from my lord's report, that award is still speaks. So this will be.
So you want to say that even if there was any enhancement, there could not have been any payment of resolution. And so far as the interest is concerned, the amount has been retained by you, isn't it? Whatever compensation was there,
We paid them.
you paid them, and
And
now
we
there
were
is an
retaining it.
enhanced compensation
Enhanced compensation. So
with respect to the date of acquisition, 1971.
yes, that is there.
So
But
you don't want to pay interest on that.
post-award interest at least it has to be. And the Act is silent on interest.
Post-award interest, the arbitrator has power to grant interest. If the act is silent, then the power
That
of
is
the
what the
arbitrator-
Honorable Apex Court has dealt. That you interest on interest cannot be given.
interest on interest
So
cannot
the
be given.
9% is running from the award. 9% is running from 71.
70.
And 15% on this 9% will also accrue for me. So in my humble submission, that what I could understand from the ratio of the judgment, that this is
Now
the
there is a
proposal.
judgment also that interest awarded or otherwise it is an executable decree so far as award is concerned.
Yes. Civil court, that the act itself says, if I just place that that was also one of the query that fell
Yes.
on my legal issue. That is, I'm just placing that section. Just a minute. Section 12. Computer and ability to have certain powers in this everything, the computer ability of computer. These are power values. So execution, because there in under Industrial Dispute Act it is said it is akin to decree. So those are executable. Here it is silent on that. Rather, Section 19 bars the jurisdiction of civil court. Section 19 bars the jurisdiction of civil court.
So how will they execute this?
I will verify in other cases how they have done it. So we take it that they are bound by the order of the courts which will be proceeded, but I will verify in other matters what they have done.
The interest gets computed, the interest up to the date of the award gets computed and it partakes the character of the principal amount. This is the concept of principal sum adjudged under this principle.
Arbitration Act, it follows there. Arbitration we have done, so it takes in that shape.
And that is why this principal sum adjudged includes the interest awarded. And post-award interest is on the entire amount. Interest cannot be excluded.
So that we are trying to draw our and gain our understanding from the judgment that we have placed before you.
Where
What is
it
coming
says
that is because it is we also find in arbitration, to be fair enough, that once it is adjudged and post, because if the person will hold the amount, it is bound to have a reducing effect.
That's right.
But anyway, that is the judgment.
That is the judgment which you have cited. 20, volume 10, 2010, 3 SSC 67.
That is one. 2010. Other point. Now, since I have concluded,
On the point of interest.
Interest is the other one. It's
Other
2005 3 years.
This is constitutional bench.
10 is constitutional bench, which I cited on the principle of interest, solution, recovery, everything was dealt with. Other acts have also been dealt with. It is 2-page judgment on the interest.
Yes, it is 2 pages. It is not constitutional bench.
No,
it is
the
a
other
division
one,
bench.
2010.
2010 is the division bench.
Then the one.
2003 is the constitutional bench.
Yes, and 2000, the constitutional bench which I have cited is 2003-5.
Yes, 3-5.
Yes, it is on interest, solution, everything has been dealt with. And solution, it has been categorically dealt with. So because 30% solution has been awarded. And it is not a peculiar facts of the case. This case does not, and there the Honorable Apex Court also holds that this will not be treated as precedence. The one where it was awarded. Recovery,
वो इंटरेस्ट वाला पोर्शन कौन सा है?
your leadership is 2003.
2003.
Yes, I'm just reading. Para 31, it confines on solution when it returns the finding on the issue. Para 31, it is only on solution. and 36.
It's not an interest.
It is on solution.
You see the interest on solution
Is also not.
and then interest on that part of the interest
Yes.
was
That
held
is
to be bad enough.
And the 2010 judgment, it says post award interest is not. The 2010 judgment. It says that there are 10 on this, there are 10 in the
Any news we shall see it. Let's hear them.
Yes.
Responding.
Your Leadership, my counsels are there in different courts. I am required.
Yes, yes.
I seek your permission.
But you
I will
just
be
whatever you have argued, you
I will
just
be
put it
noting
in
down
writing.
tomorrow itself. It will come
Yes,
because
the
I was
notes
just
should be there, the paragraphs and
everything.
there.
Everything.
Because
To the
I have
best
not
possible
taken
of my ability, I
detailed
will
notes.
extend.
I have not taken a detailed note.
I will
So
be giving
therefore,
every paragraph.
assuming
what
that you will be.
tomorrow itself.
Yes.
Will not be day after tomorrow.
Yes, yes, yes.
Yeah, please. Lord, since my lady has already gone through the background of the case, I did not bother my lady with the backgrounds, my lord, why the Supreme Court has returned it back to the
That's right.
appointment of arbitrator, etc. My case is very simple. We are from a downtrodden society. We are having no access of any governmental documents and they are all policy, etc. Our land has been taken in 1941. 41 to 71, my lord, we were receiving something or not receiving. In 1971, my lord, the acquisition took place, and again we are subjected to nowhere because no compensation, etc. would have been paid to us. We have received certain things, and then, my lord, the arbitrator has not been appointed. We don't know whom to approach, how to approach. My lord, the government is sitting over there. Section 7 says, no, it is the responsibility of government in case there is no agreement. I'll read Section 7 for my benefit. It is the responsibility, my lady, of the state government to appoint an arbitrator in case there is no agreement. Admittedly, in this case, there is no agreement because the statutory form, etc., has not been filled by the person. It is never referred to the government, and the government did not appoint any arbitrator in this matter. And therefore, the Supreme Court comes to the conclusion: yes, there is no agreement. You please appoint arbitrator. There is a delay in appointment of arbitrator. So therefore, in the time-bound manner, it was directed to sum up all the matter, my lady, and it has been decided so. We were expected to put up before arbitrator all the material, whatever is available with us, to the arbitrator so that he can not find out the just compensation. Just compensation, it is the whole sole discretion of the arbitrator only. It is only the arbitrator, not his position is very unique under this act. In a land acquisition, my lord, the valuation is entirely different. Here, my lord, the independent person has been given this task, my lord, to hear both the parties and then decide. So it is, my lord, a determination. It is not adjudication. It is determination. So determination of the quantum to be paid to a person, which should be a just compensation. For that, my lady, he has to take into consideration all the judicial principles, number one, which is time to time given by the Honorable Supreme Court, by this Honorable Court, my lord, and by the independent sources. He has to gather all the information to come to some conclusion that this price which I am going to award is a just. So make it just, my lord. He can appoint any independent valuer also to fix the price of the relevant date of acquisition. This is the scheme of the Act itself. The Supreme Court has said that whatever the material you have been given, because the purpose is not to say no to the escalated price. The purpose is to provide the just compensation. And therefore, my lady, to keep it just, he has to appoint all the persons to face the price, to take the evidence from the state as well as from the claimant, to determine all the judgments of the Supreme Courts or of the same nature of land which is already taken under acquisition. Award is given, judgment is pronounced on the nearby land, considering the value of the land, considering the position of the land, size, the amenities available, infrastructure, loss occurred to a person who is the owner of the land. And in this background, we have given them the force ID of the village under acquisition. We have given the three judgments, in which the determination of price, considering all the argument determined by the Supreme Court, is far greater value than the award is given to us. In 1954, when Triveni Devi traveled to the Supreme Court, Supreme Court has considered and given a value is 1,53,000 per acre. But in 2014, when this award is pronounced, we are receiving only 42,000.
The amount of compensation is referable to the value of the property on which date?
On the date of acquisition.
So valuation has to be on the date of acquisition. And what would be the date so far as the nature of land is concerned?
It is always a date of acquisition. In some cases, it is date of possession if there is a delay in possession and the acquisition. So it is always for any matter.
But as per section 8,
Right.
it is referable to the date of requisition. What do you have to say to that?
Sorry,
Which?
date of
Requisition.
requisition. I am so sorry. 8 had two parts. At some point of time, this second part has been set aside by the Supreme Court declaring ultra vires, because it was putting restriction on determination.
Which
Yes, sir.
judgment? One judgment saying that it is ultra vires is enough. Which is that judgment that?
That is the Constitution Bench judgment.
Which one?
That I will provide. Yes, sir. It's the Constitution Bench judgment. Manager.
Because that
Yes.
is that he has been arguing since yesterday. That it is the date of requisition which has to be taken into consideration.
Yes, so yes, sir.
No, I don't. Please show me that judgment.
Yes. It is given the Spari case, it's a Constitution Bench judgment.
Just your judgment taken.
1967, SCC online.
1967
67, SCC online.
SCC online.
Supreme Court 149.
Supreme Court
149.
one.
I'll put up. Because I have heard my lot the
So according to you, the same condition as was at the time of requisition and being sold on the date of acquisition.
Please.
So this part that it has to be referable to the date of requisition so far as the condition of land is concerned has been set aside.
Yes. It has no not connect with the date of requisition. Requisition is 40 years back. Today is the acquisition. My entire right has been taken away today.
So requisition is 40 years back.
Correct.
If we value the property as on date,
As on-
the date of acquisition 1971, then under such circumstances, any immovable property standing on that particular property will also be valued.
No, there is not the law says the nature of land.
That's right.
Its proximity, my lord, to the town, to the kasbah, to the city, to the major cities, my lord. Its proximities to the amenities, standing, building, etc., my lord, altogether a different thing. But if there is an amenity, there is a things which serves, my lord, the public purposes.
That's
So the potentiality of the land to be considered, my lord, keeping in view all those amenities, infrastructure, proximity, it's my lord, the
So my
potential.
question is entirely different.
Please,
When we take a land,
please.
all the immovable property standing on the land is to be valued.
Please.
If it is referable to the date on which the acquisition takes place, that is in the year 1971,
Please.
suppose a building has come on that in the
Yes.
meantime, because the date of requisition is around 40 years back,
Please.
then by determining the compensation, then the land and building both has to be taken into consideration as on the date of acquisition.
Yes, sir. Even the future use of the land to be taken into consideration. The future profit may not to be taken into consideration. It's my land. I have been thrown out of my land, my lord, I cannot utilize it further. You are paying me something of today's value. Suppose if you are just making deduction of all amenities, because 40 years back you have taken right. After 40 years you have taken, my lord, the right of land. So first is the easement, second is, my lord, the right, everything has been taken away. And the period is, my lord, the 40 years. So when my right is taken away, that point is crucial. Paragraph 25 of this constitution means very clearly, particularly says, it's a date of acquisition which will be taken into consideration for determination of
Valuation. Date of acquisition.
date of acquisition. In some cases, no, it
They
is
want to argue that the nature of land is agricultural and that at the time of requisition, that is 40 years back, and then they want to argue that at the time of acquisition of the land, the nature of the land has to be necessarily taken as agricultural and the valuation which is available in the 1971 is to be taken into consideration.
there is no such mechanism available as on date not to consider all these eventualities. What is the criteria to determine why we are taking about the recent edicts, recent judgments? There is no value of it. If bona fide purchaser may not taking something in 1971, so are the arbitrator going to may not consider something 40 years back's value may not
That's
based on today's sales can't. So no mechanism is available as on date. It is only a date of acquisition. Purpose is not to deny compensation. Nowhere Supreme Court says
No,
you please don't
Nobody intends to
Nobody.
deny.
Yes, sir.
Nobody intends to deny compensation, but the wordings of section 8 is such.
Yes, sir. And that is why it was not section 8 to be is just struck down as ultra-virus because it was creating restrictions. It was creating restrictions on the power of arbitrator not to determine the price. It's not adjudication, it's just a determination. So it is taken.
What else?
So, in order to show and suppose to indicate a just and fair price, whatever the documents we have available at that point of time, we have, because the government also did not have those much of documents to establish that the price of having some contradiction, what is supposed and what is proposed by the claimant. None of the document has been produced except those agriculture valuation of the land, etc., which has arbitrator and minority has already considered the authenticity of those documents. So it has been denied. So what did I put up before the arbitrator was? Few judgments. Mansoor Hassan. It was acquired in 1971. Mansoor Hassan does not know. I'll just show him, Lord. Yes. I just want my lady to put just attention to a few lines, Lord, and then I'll show the documents.
Mansoor Hassan.
Mansoor. Lord, I'll show the document. First, I just want to conclude the background
Yes,
of my submission.
this particular,
Please.
this is para number. You say para number.
It is Exhibit 4, ma'am. Exhibit 4 in the document. By the tenant. Acquired on
In
Lord
this
Mansoor.
constitutional bench judgment I have got.
Yes, sir. Para number 20.
Para number 23.
May I read, my Lord, paragraph 22?
Yes.
The argument on the behalf of appellant that the basis did not provide for the payment of just an appellant could not be assessed by this court because of the fact that the appellant had produced no material on what its plea could be sustained. In this case, however, there is no such difficulty. Clause A, Section 8 lays down a principle aimed at giving the owners of the land something which approximates its just equivalent on the date of acquisition. So it is read by the Supreme Court. So it is the date of acquisition. There are the other judgments also. This is the date of acquisition.
Their argument is something else. Valuation of the property has to be done on the date of acquisition. But they argue that the nature of the land is referable to 40 years. Like if 40 years back if the land was agricultural land, and in the meantime, from the date of acquisition until the date of acquisition, it has converted into something else. Then the land, nature of land, which was 40 years back, has to be taken into consideration, and the valuation should be the valuation on the date of acquisition. This is what they are arguing.
So this argument is legally not fallacious for the reason we are taking always into consideration, my Lord, the date, relevant date is the date of acquisition. Say read on the date of acquisition.
You kindly read this paragraph further, clause B, however,
Of the same.
of the same judgment.
Clause B, however, direct the arbitrator to measure the price arrived at in terms of clause A with twice the amount of money which the requisition property would have faced if it had been sold on the date of requisition, and to ignore the excess of the price computed in terms of clause A or that in terms of clause B. The position bears suppose similarly in the facts of Bharat Energy case that the legislature directed that the excess of the value of the land arrived at in term of Land Acquisition Act over the value on 31st December such and such.
What is this
was
twice
to be
the value?
ignored. Sorry.
What is this twice the value?
But earlier it was said in the scheme of the section 8 to be ignored that either you take this or you take twice of the value of the property at the time of the requisition and whichever is less.
Okay.
So this has been discarded by the Supreme Court saying it has the two problems. Number one, it's lowering the value. Secondly, it's creating restriction over the arbitrator. Then therefore, there was no need to appoint an arbitrator to determine the price. Determination takes place the independent view of the arbitrator. The arbitrator is the only authority under the Act which can take place and which can determine the price of compensation. Please. So, I give as many as 3 judgments. these three judgments is, number one is the Mansoor Hasan, which is Exhibit 4. Acquired acquisition date was 28 August 1972. Relating to ward number 5 and 6, our land, our 4 villages are situated in ward number 4. I am in ward number 4. This land belongs to lot 5 and 6. Compensation was determined lot 2,500 per decimal.
The property was in Doranda.
Yes, correct. And it was determined about 2,500 rupees per decimal. Per decimal means it's 2,40,000 per acre. But since it is recorded by arbitrator, since it is close to the railway station and the bus stand, so therefore I am not considering this land for the purpose of valuation of compensation
So
in your land.
this exhibit has been discarded.
This exhibit has been discarded.
So what do you have to say to this?
Our submission is, in our statement, we have already reflected the land is ward number 4. So I have two submissions not to be. Number one, if there is distance, how it is not as it has never discussed in the award. If there is a distance, something has been reduced on account of distance from this land. I am ward number 4. There is no discussion how far I am from ward number 3, where this land is situated, number 1. Secondly, I have deposed in my affidavit that my land is nearer to several amenities which is reflected by my learned friend also, and my review has already gone through. And also near to 2 railway stations, not 1. Here it is a 1 railway station, I am not, my land is nearing to 2 railway stations. If my relative will see the deposition of Virender Mato, who is claimant number 1. Who says? If I read my
I hope that you have put all these things in your written submission.
Yes, it is process. It is process, and since my learned
no, you have already furnished some kind of.
I have given it is a part of record also. I put my own written
So
submission.
because you see there are so many things that you are referring to.
understand.
So with respect
conscious.
to each of the exhibit, you should put it in your written submissions.
I'm conscious.
Right? Whatever you have argued, you should put it in your written
I'm sorry.
so that nothing is missed out.
Please. I'm so deeply blessed. And since my learned friend has put up so many judgment off the cuff, so I need some time to read and then reply if the reply is needed. Otherwise,
Certainly.
all those things are already settled by the Supreme Court in various judgments, not only one. And there is a constitutional bench judgment, there is a full bench judgment which says Solatium interest, Ajay Singh, etc. is holding the field. If you let me kindly see paragraph 3 of the deposition on the behalf of witness number 1. यह कि चारों गांव के सेकंड यह कि चारों गांव के बहुसंख्यक भूधारी आदिवासी तथा पिछड़ी जाति के हैं तथा जमीन बिकने में सरकार से अनुमति लेने पड़ते हैं अतः गांव में बिक्री पत्र बहुत ही कम है इससे छोटा नागपुर टेनेंस एक्ट में रिलीज इज अवेयर ऑफ the restrictions and permission of the government for alienation of property, so therefore यह कि अर्जित जमीन को राष्ट्रीय राजपथ 35 के बगल में है जमीनों का मूल्य बहुत ही अधिक होना चाहिए इट इज सजेशन यह कि रांची शहर का फैलाव उत्तर की तरफ बढ़ रहा है और शहर से 4-5 किलोमीटर की दूरी कोई मायने नहीं रखती है इस शहर का फैलाव अब विकास विद्यालय तक हो गया है जो इन जमीनों से 5 किलोमीटर उत्तर में स्थित है इन चारों गाँवों को भी नगर पालिका क्षेत्र में मिलाया गया है इज ऑलरेडी मर्ज्ड इन म्युनिसिपल एरियाज इन चारों गाँव की जमीन रांची शहर का एक भाग है यह कि चारों गाँव की जमीन रांची शहर से सटा हुआ है अतः जमीनों को शहर की जमीन मानना चाहिए चारों गांव 3 तरफ से नदियों से घिरा हुआ है सो वाटर बॉडीज आर आल्सो देयर गांव के पश्चिम राष्ट्रीय राजमार्ग 33 है उससे सटे पश्चिम रांची शहर का सीमाना शुरू हो जाता है जहां लाखों की आबादी रहती है जहां शहर की सारी सुविधाएं प्राप्त हैं जैसे बाजार बैंक स्कूल होटल पेट्रोल पंप, डेली मार्केट, तरह तरह की दुकान, ऊंचे महल दुकान आदि उपलब्ध हैं। उच्च राजपथ 33 के सटे वार्ड नंबर 7 है, उससे जिसे ऊटी मोड़ के नाम से जाना जाता है, जहां सभी तरह के व्यावसायिक काम होते हैं। बिजली, पानी, सड़क की सुविधा है। यह कि खटंगा तथा लालगंज गांव के बीच से उच्च राजपथ 33 से PWD की पक्की सड़क उच्च राजपथ 32 पुरुलिया को जोड़ता है, जो बीते सवे 1932 से मौजूद है। इन सड़क के दोनों किनारों की जमीनें जो अपग्रेड 1971 में किया गया है, भवन बनने योग्य है तथा जमीनों की कीमत 2 लाख रुपए से अधिक है। यह कि चूंकि चारों गांव 3 तरफ से नदियों से घिरा हुआ है, अतः गांव की जमीन में सिंचाई की अच्छी व्यवस्था है। ग्रामीण लोग साल में 4 फसल लेते थे और साल में प्रति एकड़ 20,000 रुपए की आमदनी होती थी। सो ये सजेस्टेड नॉट द इनकम रिसीव्ड फ्रॉम क्रॉप्स। यह कि गांव के उत्तर में गेट लातू गांव है, जहाँ शहर की आबादी है तथा ऊंचे ऊंचे मार्ग फ्लैट बने हुए हैं, पेट्रोल पंप, होटल, दुकान है। गांव से सटे उत्तर में BIT मिश्रा इंजीनियरिंग कॉलेज है, BSNL बैंक का मेन ब्रांच है। अतः 4 गांव एक दूसरे से सटा हुआ है। दिस इज द admitted position by DLO himself that it is a contiguous और विलेज। दक्षिण पूर्व में नदी स्वर्ण रेखा के पास सटे टाट सिलवे गांव है, जहां तरह तरह के उद्योग धंधे हैं, कारखाना है। उषा मार्टिन का रोपवे का कारखाना एक्सेट्रा, जिला स्कूल, राजकीय उच्च विद्यालय, हॉस्पिटल, चावल मिल, आटा मिल, ट्रांसफार्मर कारखाना, SCI गोदाम कारखाना तथा फैक्ट्री है। उसके बगल टाटी सिलवे रेलवे स्टेशन है। गांव के दक्षिण में नामकुम रेलवे स्टेशन, पेट्रोल पंप, सीमेंट डिपो, उच्च राजपथ 33 में ओवरब्रिज बनने की जो जमीन सरकार ने ली है, उसका मूल्य प्रति एकड़ 30 लाख की दर से न्यायालय ने तय किया। This has been determined at the rate of 2,50,000 per acre.
This
But
is
this is just
what
a-
you want to draw a comparison between between Exhibit 4
Madam,
and the nature of this property and the surrounding of this property.
because I am discarding this particular exhibit has not been considered by the arbitrator for the reason this particular land is not situated near to the railway station and bus station, and he assumed that we are not close to the railway station and bus station, therefore this judgment has not been taken into consideration for a base price to determine not any compensation to us. This is my submission, because my statement, my deposition has not been rebutted by any of the respondent. There were 2 respondents. Nothing has been suggested not contrary to the existence of railway stations, engineering colleges, factories, etc., basic amenities, water bodies, existence of NS 33, SS 32. So all these amenities are very much there. I also exhibit one which reflects which need not require any statement from my side, which speak itself. The presence of 33, presence of 32, and all the villages are not contiguous near to the Ranchi Malot city. They have all the basic facilities, all the water bodies, etc. So that we not require anything to be established. It is established.
So your sheet anchor is Exhibit 4.
No, my sheet anchor is Triveni Devi.
This Exhibit 4 is, what is the valuation?
It was 2,500 per decimal. So it is 2,50,000 per acre.
And the awarded amount is 41,000.
In our case, not 41,000. My sheet anchor is not the judgments of 1954, which says 1,35,000 after all deduction at that point of time.
It was from Jharkhand?
Sorry?
It was from this part of the...
Yes, ma'am. Because that belongs to 3. We are in 4. And this word Mansoor Hassan is ward number 5 and 6, which is far away from us. If you take everything in contiguous situation, so 3, 4, 5 and then 6 more. So 5 and 6 are getting for 1971 acquisition 2,50,000, and we are getting
This is what number?
This is ward number R, ward number 4. Ward number 5 and 6 is Mansoor Hassan. Acquisition date is 28 August 1971.
Twenty-eight 671.
28/8/1971.
28.
I'm so sorry.
Date of acquisition.
My fault. 28/8/1971.
So this has been rejected by the.
So this has been rejected. Although it is 5 and 6, I am on number 4.
5 and 6 may not be in continuity.
It is actually I could have understood. But the problem is, it is the submission of the government itself. It is a contiguous and in continuity. That I will show you. And nothing has been suggested contrary. I can understand if you put some question, something that's come out from the statement. That no, it is far away from.
There is a discussion of Exhibit 4.
Please.
And what was the area involved in Exhibit 4?
Please. Then, my lord, I gave Exhibit 12, my lord, which is a Triveni Devi. Triveni Devi judgment is, my lord, comes on 25th January 1972, which is Exhibit 12, my lord. Acquisition took place on 7/7/1954. Location is ward number 3, and compensation awarded, my lord, 1,35,000 per acre.
This also has been rejected.
This has been rejected for the reason the learned arbitrator, my lord, has considered this land on the main road. However, this factual assertion, and my lord, the finding is incorrect for the reason that main road land is, my lord, the Ranchi Club land, which has been confused, and it is mentioned that this land is situated, my lord, on. However, the land's position is given as ward number 3. That I'll show you. This is also not considered. Then, my lord, the Exhibit 6 I give you. It's a judgment again. Sagar Tirke. Judgment date is 2012. Acquired in 2007. Village is Namkum. And compensation awarded 30,000 per decimal.
That is 3 lakhs.
30.
Per decimal. Per
Yes,
acre it
30.
will come to
It per acre becomes similar 30 lakhs
30 lakhs.
in 2007. And this has not been considered because of its positioning. Mentioned better position.
This was located where?
Namkum village. It's a Namkum village.
Namdil. This you have referred to exhibit number. I just.
This is exhibit number 6. I'll just give a short notes which
Yes,
reflect
sure.
each and every valuation and positioning of land, etc.
Exhibit number 6.
Then I give a judgment on exhibit 5, which is relied upon by the learned arbitrator. Sunny Sharwa Lakra. It was decided on 9th March 1998. and the rate determined is 2 lakhs rupees. Then I gave my lady Exhibit 7.
Exhibit 7. Yes.
Exhibit 7, which is a sale deed of 1963,
Yes.
which is very important. Whatever the documents we have available at that point of time, we just put up before the learned arbitrator to take a decision, in totality, considering all the aspect, negative, positive, whatever we have available. As on date, I am appearing before my lady. My duty is not to assist the court, to come to some just conclusion, my lady. So whatever is against me, whatever is favoring me, I am bound to display. I am bound to put up before the court. So sale deed dated 19 June 1963.
This has been considered.
All four has been considered. Exhibit 5, which is Sanichara Agra, Exhibit 7, 8, 9. So these sale deeds are 3 sale deeds. So sale deed of 1963, it's a 24,000 rupees. 1963, this is very important. This is the sale deed of 1963 and 24,000 rupees. This has been taken into consideration. Sale deed dated 13th November 1962 of Jharkhand is 30,000. And the very last, Exhibit 9, sale deed of Village Gully of 1971, which is contemporary one, because it's 1971, it's contemporary one, it is 27,000. So in 63, 24,000, then 62 million is the 30,000, and even down the line, it is 27,000. So there must have been a situation before the learned arbitrator. So what he has done, he has taken Sanichara higher side, 27 is the lower side, increased Marod village by all three, sadly he has taken into consideration. He has increased Marod 10% cumulative till the date of 71 and decreases from 1986 Sanichara Lakra to the date of 1971 and then average out. My respectful submission is it is always brought before any adjudicating authority to adopt some mechanism. Lord, I can't criticize that because it's a responsibility. One has to meet up to the expectation. But my respectful submission is, Lord, when something is decided by Supreme Court, something is decided by this Honorable Court, and of the contiguous area, it has to be taken into consideration. Because we are destitute, we are marginalized, we are having no means to survive. 1940, we are in 2025, again 5 years, the government definitely going to file an appeal against whatever is the come out and result. So we will be subjected to 5 years more if we are not very lucky, otherwise it will take 10-15 years in Supreme Court itself. So this is the third generation which is contesting these litigations and award. And very meager sum has been given to us as a rent, as some determination, no fair compensation, etc. And we have no option even otherwise. We are bound to take whatever they give, we are bound to take. We are at the receiving end. Even if it is decreased, we are bound to take. We can't say no. We don't have means to survive today. Neither we have a land today, nor we have a compensation today. Those 1 lakh person has been displaced. Where have they gone? Nobody knows. Their lives are in misery. No one is bothered. No one has time to think about them. Because the law says something. Bureaucracy has its own speed. They are always fixing negative responsibility. I should inform. Why should I inform? I am not filling your form of agreement that constitutes a dispute. You should appoint arbitrator within time. So this was not the background.
Yesterday my query was that,
Please.
let us take it that the lands are contiguous.
Please.
Standard value has to be fixed for each corner of it.
Please.
This was done by the DLO also.
True.
He gave the same valuation.
Uniform, yes.
Uniform valuation
Yes,
was taken
yes,
for
yes.
the entire land.
Yes.
Now, in a case where a particular sale deed or a compensation relating to the same period is available, sale deed is available,
True.
exhibited, where was the occasion of for the learned arbitrator to enter into kind of back calculation or forward calculation? Was that required? Because the question of taking this method would arise if there is no material. It is not a case of no material. You have a specific sale deed with a particular year which the arbitrator accepts also that should be considered. Then where was the occasion for him to refer to the sale deed of 1962 or to refer to the sale deed of 1984 or any document of 1984 and then undertaking the back calculation and front calculation and come to a figure with respect to those and then take an average? Is this the method actually prescribed in the law?
Actually, whosoever is the determining authority, it's always very, very difficult for him to assess the just compensation, even in land acquisition cases also. So here, my lord, when it is the acquisition, and the responsibility is given to a particular arbitrator, my lord, he is not bound by any document. Suppose there is no document, he can fetch the report from the outside agency, he can determine.
No,
It is
he
his
can
wisdom.
determine, but that
Correct.
determination has to be based on some material.
True. So
Right.
I'm just coming to that. So what has he to consider, my lord? He has to consider the area involved in that, my lord, sale, bona fide of the sale, the proper value determining, proving of sale deeds, my lord, etc., which has not been done in these cases, because these cases, my lord, whatever we face, my lord, it is given to them. Unless my lady puts some query, my lord, I am not able to reply. So if you are putting some query, my lord, it is good for me to reply. Otherwise, I am thinking that everything is just okay.
That's it.
So I gave all the records, my lord, and material with us to the learned arbitrator. I argued, my lord, vehemently. My vehement submission was, I am very much depending because it's a judicial determination. The value of 1970, my lord, one sale deed, maybe a distress sale, maybe having a very small area, maybe the lower valuation is given. The nature of land may have not a different value altogether. Maybe it's a backward, forward, nobody knows about location, etc. Nothing has been discussed. And when I am giving about 3 sale deeds, it's very difficult to assume that in the 63, 62 the value is 30,000, 24,000, and in 71 it is 27,000. How any prudent person can accept any document, even it is not relating to that particular years, but that has to be bona fide sale. That has to be proved. That has to be something which shows the bona fide of the transaction.
So you are defending the award or you are seeking enhancement or what?
I am seeking enhancement. I am seeking enhancement.
So you are
Because
also
my
assailing
ladies-
the award.
I am saying. I am assailing for the reason my document which should have been considered by learned arbitrator, because if I am putting a Supreme Court's judgment relating to ward number 3, even if you are considering that I am little far away from those basic amenities, suppose what is involved in that particular ward number 3, you can make certain reasonable deduction.
Which one is your best piece of evidence?
My best piece of evidence is the Triveni Devi. Triveni Devi, which is exhibit number 12.
This is 1963 document. No.
It's a judgment of 1972 and acquisition of 1954. So for 54 acquisition.
Amongst, no, you see, we cannot, I think that you should be referring to those documents which is approximating point of time
Please.
with respect to the acquisition of the land. 54 is too far away, and learned arbitrator has not considered that document.
No, he has not considered the document not for its being old in nature or having the remote from the date of acquisition. That can't be. If the value of certain land, just for the sake of argument, if the value of something is so high in 1954, can it be imagined that in 1971 it comes to only 27,000 or my lord the 42,000? Would that be believable, my lord? And when I am giving my lord back to back 4 judgments, and every judgment showing lakhs, you are giving me in thousands, and that too you are determining on the wrong assumption. The land is situated on main road. It is not situated on main road. Main road land is, my lord, which is exemplified in that case. This land is a part of Ward 3. I am Ward 4. So my respectful submission is, if there is, my lord, more than 1 or 2 or whatever is available, and the price shown in say deed consideration is not seems reliable, you could have considered it. But when there is nothing, in 1963 said deed shown you some prices, and the 71 price show you not the slice down, no increase, it is not believable. And the land parcel is very small, so we don't know about the nature of land. The intent of transaction, etc., is nowhere discussed, nothing mentioned. So he has very safest way adopted, taken 86 at the higher value because he just imagined something decreasing formula, and he just enhanced of 27 up to the level and then average out our 4 comes to 41,000. So the person is more lucky whose land has been acquired in 54. I am most unfortunate, my land is acquired in 71.
And in 54, what valuation was given?
It was phased Triveni Devi 1,35,000 per acre. In 1954, if the same quantifier applied to this case, it comes to more than 7,30,000. But I am asking only 2. Am I not entitled, against
What
this?
is the reason for rejecting?
Rejecting is the situation of land. Triveni Devi on main road. This is the only reason. It is not main road land. It was the Rachi Club land, which was the main road land, which was exemplified in that case.
In Triveni Devi.
In Triveni Devi. I will show you.
Rachi Club is actually situated on the main road.
True. True. That is the main road land.
See, we are aware about the locality.
True.
Rachi Club is actually situated on the main
Definitely.
road, and the position of your land is much far away from this place.
No, so I am not comparing with the Rachi Club land. I am comparing my land with the Triveni Devi's acquisition land. It was exemplified in Rachi Club land. I am not saying.
In Triveni Devi,
Yes.
which is the land it was acquired? Rachi Club land? No.
No.
Which was
In
the land?
Triveni Devi, ward number 3 land was awarded, was acquisition, and the award has been made. In those cases, club land was exemplified for determination of value, etc.
That's right.
As I am
Yes.
all these things. So in 1954, the land's value is 1,35,000 after all deduction. And in 71, we are most unfortunate, we are getting nothing. And that too after half of the century, more than half of the century. Even today, period to be considered. I am just requesting to my lord and considering the award of compensation. So this much of delay. I just read the affidavit given by Virendra Mathur.
Yes, we have read it.
Please.
You have placed it, I think.
Yes, I'm sorry to bless you. If you ladies can kindly come to me. Triveni Devi, please.
Yes, I am there only. I am in
Please.
Jharkhand. So if there are 2 judicial pronouncements,
Please.
One is relating to acquisition of 1954,
Please.
and another is relating to acquisition of.
36.
No, this is relating to acquisition of 1971. Isn't it? This 30,000. Exhibit 6 is.
It's a 12.
Exhibit 6 is which year's acquisition?
2007.
This is 2007.
Yes, determined on 2012. Judgment.
There is one judgment which relates to this one, Mansir Hussain. This
Yes,
is relating
Mansoor.
to 1971.
71.
Now we have two judicial pronouncements.
Please.
One is relating to acquisition of 1976. Other is relating to acquisition of 1971.
I'm sorry.
So therefore, under such circumstances, should the adjudication in relation to 1954
Please.
be excluded?
Actually,
You are just referring to it to show that even at that point of time there was such valuation. But when it comes to quantification of valuation and quantification of the market value of the property, then the settled principle is that proximate point of time is to be taken into consideration. If it is away, it has to be discarded, irrespective of whatever be the value. It has to be discarded, right? So therefore, amongst all the judgments that you are citing, it is Exhibit 4 only which could actually help you.
Melody, my submission is, my entire effort is to show how precious this land were at the time of acquisition. That is my efforts, not because I am in the hand of learned arbitrator, I am in the hand of the Supreme Court. Even in the opposed Supreme Court, Lord, it is always for honorable court to decide. But my effort is to put everything before the court so that a conscious decision can be taken. A land which is so precious that in 1954, 8 lakhs around rupees is given for per acre. Even in 2 lakhs 50,000 is given in 71 in another judgment. And the person in between these two plots, because plot number 3 is Triveni Devi, plot number 5 and 6 Mansoor Ahmad, and plot 4, getting only 42,000. So I'm just putting everything to show my.
So according to you, just a moment, let's make a chart.
Please.
Exhibit 1 is the map.
Exhibit 1 is the map.
Exhibit 2 is
Exhibit 2 is the notice of land acquisition.
Exhibit 3.
2
Exhibit
A and
2 by A and 2 by B.
Yes.
Okay. Exhibit 3 is
3 is village very.
White copy of the Khaitan.
Khadiya. Then 4 is the judgment 92. Mansoor Hassan.
Exhibit 4 is
Mansoor Hassan.
this is judgment.
Mansoor Hassan versus State of Bihar.
Judgment dated
It's a judgment dated 6th February 1990
6 to 1990.
for acquisition of 28/8/1971. For acquisition
28/8/1971.
71, ward number 5 and 6. This also mentioned.
Ward number
5 and 6.
5 and 6.
Compensation
Compensation fixed at
2,500 rupees per decimal.
500
Per decimal.
per decimal.
Mansoor Hassan.
That is 2.5 lakhs per
Acre.
acre.
Correct.
Then exhibit
5 is
Five.
Sanishar wa Lakra. Sanishar wa Lakra. Judgment dated 9/3/98 for acquisition
9/3/98.
for acquisition of 1986 village Utiyatu 2000 per decimal.
1986 acquisition.
Yes,
This is how much? 2000?
per decimal. 2000 per decimal.
Yes. Okay, exhibit 5. You have exhibit 6.
Yes. Then exhibit 6 is Sagar Devki. Sagar
It's
Devki.
judgment?
It is judgment matter decided on 9th May 2012,
9/5/2012.
acquired on
Acquired on
20th March 2007,
23/2007. Rate
and the rate is 30,000 per decimal.
any ward number given?
It's
This was acquisition for National Highway 33.
it's yes, any 33.
Khata number 35 and 32. What is the rate? 30,000 per decimal. Exhibit 7 is
Yes. Say lead of 1963.
1963.
Yes.
Rate
Rate is 24,000.
per
Village
district.
Gari. Village Gari.
Per district.
Uh, yes, ma'am. Yes.
Which is one of the villages which has been acquired. Exhibit 8.
Exhibit 8 is a lead of 1963.
1962.
Rate is 30,000.
30,000.
Correct. Correct. Correct.
This was also 24,000 per
Per
district, per acre.
Correct.
Say 90 per acre. Okay, this is all per acre. Exhibit 6 is per district.
Yes.
Exhibit
Exhibit
6
6
is
is-
per district because it is 2007. So 3 lakhs. 3 lakhs per acre. Exhibit 6 is 30,000.
30,000.
Okay. Exhibit 8 is 30,000 per acre. Exhibit 7 is 24,000 per acre.
Yes, sir. Then
Exhibit 9 is
71 city village Gari.
71 say 80.
Village Gari. Rate is 27,000.
Rate is
27,000.
per acre.
Per acre.
27,000.
This exhibit 9,
Right.
this is a Chapperbandi land.
Yes, yes. I'm so deep.
I'll argue
I'm
on
so
that Chapalbandi land, how it
Anand
will
will-
be increased in.
I'm so deeply obsessed. I'm
This
so
is
deeply.
Chapperbandi land. In this area, Chapperbandi lands are more valuable than the other land. And they are transferable also to a great extent.
Open land.
Open land.
I'm so deeply.
So even for this, the rate was 27,000 per day.
I'm so deeply invested. I'm so grateful. I'm so grateful.
So how do you, while referring to other sale deeds
My-
and the increase in price or backward calculation,
Yes.
how do you come out of Exhibit 9?
Really, Exhibit 9 is of 1971. So in 71, when I am showing something of backward dates, the prices are high. In 71, it is sliced down. Please appreciate. Any land value of those area in those periods cannot be stagnant for 10 years, no increase.
You
which
see,
is-
when you are saying that Exhibit 9 is sliced down, then you have this,
because others are in 1962, 63, 30,000, 24,000.
that is 30,000 per acre, no?
Two. This is
No,
This is also-
63 is 24,000 per acre,
this,
then 62 is 30,000 per acre,
30,000. Two.
and this 71 is
27.
27,000 per acre.
So it can't be stagnant for more than or approximately 10 years. It's a precious land in any way, if it is open land and it is so whatever is suggested by the deponent has never been controverted by any of the respondent in their cross-examination. Neither the location nor regarding the amenities, nor its proximity to the state or national highway, nor its potentiality has been disputed, nothing. And when it comes to the denial of 1954 price, that too on referring the wrong location, I am entitled. And the price comes to according to 54 is more than 8 lakhs rupees. If even the 30% deduction is there, it comes to a very substantial around 5,65,000 around. And I am asking only two. And that too when there is a lot of delay, 1914, 2025. It's more than
When you say that, what is the area of 1963 land
1963. Yes.
and this 1962
I'll
land?
show. I'll show.
Area is 1 decimal. 62 is 1 decimal.
1.97.
It's 1 decimal.
Yes.
Right. Rather, it is 0.9 decimal.
0.9. Correct. Yes. This is not right.
What about Exhibit 7, 1963? This is also a very small land. Extremely small. The measurement has been given in feet. This is
some chain etc. is mentioned. I am not able to comprehend that exact value.
The map is also annexed
True.
along with it. It's a very, very small
Very
piece.
small. Very small.
25 feet 4 inch.
पाँच
By-
कट्टा 8 डिसमिल के लगभग
हाँ?
5 कट्टा समथिंग
कहाँ से लिखे?
मैप से
मैप से कैसे आपको पता चल रहा है 5
लिखा
कट्टा?
हुआ है एरिया
Portion of plot.
Portion of plot number such and such, and the land area 0.5 katta 0 chata.
0.5.
Point not 5. 5. 0.5.
एक कट्ठा का कितना स्क्वायर फीट होता है?
एक कट्टा 720 स्क्वायर फीट होता है, डेसिमल होता है 435 स्क्वायर फीट
720 स्क्वायर फीट.
इक्वल टू 1 कट्टा.
राइट. आपका देखिए लैंड का शेड भी दिया हुआ है. 25 फीट 4 इंच 720 स्क्वायर फीट होता है ना. देखिए 25.4 बाई 147 या 138. आप इसको 145 ले लीजिए. ठीक है. 8.27 डेसिमल. 827 स्क्वायर फीट.
No, 8.27 decimals. 4 divided by 435 per decimal area per 35 square feet.
From where do you get this? कहाँ से
One
कैलकुलेट किए? इसको
katta.
कैलकुलेट करिए.
One katta is 720
25 into 145.
Not one.
145 यही लिखा है इसमें. It has been marked. ये मतलब जो एरिया है, जो लैंड बिका है, that has been highlighted in the map with boundaries given.
That is the length of the.
That is the length and breadth. We are finding out the area by length multiplication by breadth.
But here the area is also 5 katta.
इसको जरा 25 into 145.
4000 square.
362
360.
362
3625 divided by 720.
5.034
5 कट्ठा है आपका. साइज 63:1.
So 8.27 decimals.
8
27 decimals.
and where is rate given in the sale in exhibit 7? Rate का लिखा है. Where is the rate mentioned?
In our notes of article.
No, in your document.
In 7.
Yes, in exhibit 7. Where is the rate mentioned?
It's very difficult to read.
If you are not able to read this,
It
it's
is.
enough to discard it.
It is mentioned in arbitrator's award, like, fetch it from there.
It must be there in the document, no? Why should we see the arbitrator's award for that purpose? Where is the rate mentioned? बताइए कहाँ है इसका rate? कहाँ लिखा?
Last about 4 lines. मन मुक्ति ऊपर लेते मोबाइल 2000 रुपए नाम मुक्ति कराए थे मोबाइल 2000
ये मेंशन भी है अवार्ड में 28 पे.
अवार्ड में जो चीज आपके फेवर में है उसको पढ़िएगा. आप हमको इस डॉक्यूमेंट से बताइए इसका एरिया कितना है, इसका रेट कितना है, इसका टोटल कंसिडरेशन अमाउंट कितना है. When the document is before us, why should we read in the award? और आपके रिटन सबमिशन से तो मैं इस तरह से डाल भी नहीं सकती। क्या लिखा है? 2000 नकद दिया for the entire land. फिर 2000 पर एकड़ कहाँ लिखा है?
Total valuation of the land.
हाँ तो वही तो टोटल वैल्यूएशन की बात कर रहे हैं। The total value of the land must have been mentioned, no, in the document. 2000 nakad diya. It is for only rupees 2000. What will I assume out of this? Please have a look at it. It is mentioned 2000.
Absolutely unable to read those.
No, we are able to read
Yes,
it.
yes.
But this 9 into 2000 नकद मुकिल को दिया। तो लिखा है 2000। इससे एग्जिबिट 7 में हम 24,000 कहाँ से पढ़ें? पढ़ के कैलकुलेट कैसे करेंगे? पर एकड़ थोड़ी लिखा है। नहीं लिखा है ना। 2000 पर डिसमिल बोल के कहाँ लिखा है?
टोटल एरिया का लैंड कंसीडरेशन वैल्यू इज 2000.
एरिया का बात नहीं बोल रहे हैं आप। जो 330 ऊपर लिखा हुआ उससे नीचे पढ़िए। ₹2000 नकद मोकरी क्या है?
That is coming to rupees 24,250.
कहाँ से लिख रहे हैं?
For rupees for
He is calculating my lord for the whole consideration of the land under sale proceeds.
and
And therefore, my lord, he is calculating those value to the acres. That is all.
for 8.27 acres, then they is paying 2,000 rupees. Then
Okay.
it comes to for 1 acre, it comes to 24,200 rupees.
Okay. So this for 8.27 decimal.
This means their consideration value is 2,000 rupees.
Consideration value is 2,000 rupees. So you are calculating it
Per acre.
for acre. Calculate करिए तो सर। double 0 triple 0 by 8.27. 0.27.
Two four one eight three 1,793.
That's right. Is anything else you want to say?
Yes. Mr. Anand will address the board because he is handling these matters since long time.
Okay.
I will address all the adjustments which is relevant on the subject regarding the interest, relation, etc., compensation determination, proximity of the sale deeds, its relevance, and the constitution bench judgment, of course. I will revert which is given by my management tomorrow. And all the three judgments which I relied on in this case, I will read tomorrow
Okay.
with a better copy because it is very hazy, my lord, which is the next day. So I have a copy of SCC download, so I will provide the copy.
Yes.
Thank you so much.
May I please? In this earlier round, my lord, I appeared before the Supreme Court. So, my lord, I personally knowing how the matter is passed. My lord, the Honorable High Court, when we approached, that was dismissed for 3 reasons. One for delay, one you cannot represent all the, and one your point that you are not entitled. We challenged that before the Honorable Supreme Court. In Supreme Court, my lord, notice was issued and the same question was asked, how the 20% can represent entire village. And that too without giving the SLP, that time 150 rupees per day. So on that light, my lord, the court said, no, nothing doing. I have a copy of the SLP. We have taken a specific ground.
You will not read the SLP.
No, I am saying, Lord, I'm not reading the SLP. I am just saying, Lord. That's my argument. That taken there. Unless until there is a K and L form agreement between the parties, even though I have received the money, that does not mean I am satisfied. Yeah, there is an agreement between the parties. If there is no agreement between the parties, they have to no choice to appoint an arbitrator.
In absence of an agreement.
If no agreement, may not, why there is no agreement? Because there is no consensus. We are not satisfied. Whatever the money is paid, transferred there, as my place is saying 80%, 100%, that does not mean whether we are agreeable for that price or not.
How much time, what is the mode and method of showing that you are not agreeing?
That is the responsibility lies as per the statute to them. Can you see
Is
the
there any responsibility on your part to raise any objection?
No, as per the Act, considering the legislature intention is very clear.
So this
In that, kindly see, my lord, kindly see the Act 7,
act which is
the Act policy. Because, my lord,
just a moment. Yes. You see, there is also a provision for making an objection.
that is for requisition.
No, that
Kindly
is
see, my lord, I'm sorry, my lord, if I am not wrong. Kindly see, my lord, section purpose, power of requisition of property, power to take possession of requisition property, surrender, rights to over requisition property, all property requisition recipients shall be used for any person required under free computer of the order landlord to execute the request.
Section 8.
Section 8.
Method of determination of compensation. You read please
Yes,
section 8 once.
where any property is requisitioned or acquired under this act, there shall be paid compensation, the amount of which shall be determined in the manner in accordance with the principle herein above set out. That is to say, where the amount of compensation can be fixed by agreement, it shall be paid in accordance with such agreement. So, my lord, payment has not, I am taking pause here, the payment has not been paid as per the agreement. Whatever payment is made. That's why I am again reading, my lord, where the amount of compensation can be fixed by agreement. So, compensation has not been fixed by agreement. Then, my lord, when no such agreement can be reached, the central government shall, and you mark the word, Lord, shall appoint an arbitrator, a person who has been is qualified, appointed a judge before the High Court. So by reading to this, Lord, clause, it is very clear. If there is no agreement, you do not have any choice but to appoint an arbitrator. And that is the latches in their part for not appointing arbitrator for so many years. my lord, even inform my lord, they have to inform the higher authority. That much of check and balance in this act, my lord, that is not in Land Acquisition Act. In Land Acquisition Act, my lord, section 18, the responsibility was, my lord, for claimant to approach the reference court within 6 months.
Where was he reading 80% payment? He was reading it in the
That, my
rules.
lord, that
is there in the rules.
that is, my lord, the form. But the statute is very clear.
No, that is there in the rules. You
And
read the
rules.
Nine.
Rules can't override.
That's
my
why
lord,
you read rule 9 also.
Yes, my lord. Rule 9. Compensation. An authority to whom the power of central government have been delegated shall, as far as being associated with itself, the local officer of central government concerned with the property in fixing compensation under clause A of subsection 1 of section 8, obtain the approval of the central government in administrative minister concerned, or any officer authorized by the government in this behalf. The compensation for requisition property other than agricultural land shall be paid by the competent authority quarterly in arrears. In case of agricultural land, the compensation shall be paid either annually or release of land whichever is earlier. The compensation shall be paid either in cash or by check or discretion of competent authority. The competent authority shall, as soon as may be practicable after the making of acquisition order and serving of notice of acquisition, communicate to each person interested an offer of what an opinion of the competent authority if fair amount of compensation payable to such person in respect of the property requisition and acquired. If the owner of the property is not readily traceable or there is no person competent to alienate property, the ownership of property dispute, if there is any dispute to title to receive the compensation as to the fulfillment of the amount offered as compensation, the competent authority shall deposit in the court amount of the compensation as determined by him under clause A of section 1 of 8. The competent authority shall at the same time submit the central government a report setting forth the full facts of the case of the concerned papers apply for the appointment paper. Their check balance. You have to see whatever happened. Agar koi nahi hai, there is no person there. You have to send all this back to central government. Time to time, every person interested in whom the made in subrule 3 shall within 15 days receipt of the offer communicate in writing to the competent authority his acceptance or otherwise of the offer. If he accept the offer, the competent authority shall enter into an agreement with him or behalf of the central government in form K.
So it is no concept of deemed acceptance.
Yes, ma'am.
Read it further, Roman 2.
In the following circumstances, the competent authority may, at his discretion, may, or eligible claimants on account payment up to 80% of the amount which is his opinion likely to be assessed as compensation or recurring compensation as the case may be, when there is likely to be delay in assessing compensation, where the competent authority has made an assessment but there is a delay in reaching an agreement, though there is a reasonable prospect of agreement being reached, where it is clear that agreement cannot be reached. If the competent authority makes an account payment under clause 2, not clause 2, so what we are reading here. Clause 2, he shall enter into an agreement with the person to whom payment is
So
made.
according to you, it was a responsibility of the central government either to enter into an agreement or if no agreement was reached, then under some
He
circumstances.
has no option
But
to appoint an arbitrator.
appoint an arbitrator, and the central government did not appoint
Because
an
you are taking
arbitrator
a
for a long time.
long time. And in this,
Their further argument is that the property was, the amount of compensation was fixed and taken away as it was fixed by the government way back in the year 1975. By 1975, most of them had taken away. And then the litigant, the claimant, they rose from the slumber only in the year 1993.
that issue was final now after Supreme Court order.
No, you
That
see,
the Honorable High Court dismissed on that ground.
no, you are. I take it that you are entitled for consideration. Then
Yes,
under such circumstances, what would be the award so far as solitium and interest and these things are concerned? There is a gap of 25 years.
My respectful submission would be, my lord, my laches cannot be counted. It is their duty. Suppose, my lord, it's their duty to produce the certain thing. My lord, this Nazir Ahmad, this Privy Council, it says if something which has to be done in that manner only. It is not cast upon my duty. My lord, the poor villagers, the tribes, in my lord, earlier days in land acquisition, they beat the drums. Because they can't read they have not produced whether the act says it's in newspaper you have to publish.
Those things are not there that you were not aware. The land was actually with them only.
They
So there was-
only, but who have read the act?
That is not your
Can-
case
can
that the
we-
procedure was not followed.
Can
That is
people-
not. It is not your case that the procedure for acquisition was not followed.
No,
That is.
no.
You are fighting for
my
compensation.
case, my case is there is a delay in appointment of arbitrator.
That's right. And therefore, since the delay is
In
attributable
arbitrator,
to
in
them,
other cases which I will rely, there are more than 10-15 cases. Even in Hari Singh Khosla case, after saying that the Acquisition Property Act is not ultra virus, but after saying so, they said is there 12 years delay in appointing of the arbitrator, somewhere 6 years to appoint arbitrator, solicitation and interest should be given to them.
that's right.
3 judgment, many judgments. In view of that, Lord, kindly, for my sake, kindly read allow to me to read the Supreme Court judgment.
Could you please, both of you, all the parties, right? You have already cited whatever you have to cite. Could you please give me the list of judgments at least during the course of the day? And you are going to continue tomorrow and cite the judgments, right?
The list of judgments could also be given to us in advance to the
Yes, you will get it. What's the big deal about it?
He has not given, but we'll give them. He has not given. I'm
We have
back
given the
today.
copies.
I hope you have noted down his
Yes,
judgments.
it is noted.
Okay, we'll continue
Yes.
tomorrow. We have a different bench in the second half.
Please.
I will not take more than an hour.
So,
In our blood, I know.
And who are those 20 persons? Are you able to segregate who were
Yes,
those
Lord,
persons?
I have the. Because their
So,
argument
so their case that 100% was taken is not in dispute. It is not 80%. It was not part
no,
payment.
we are disputing that we have not taken 100%.
100% means, you see, there are two percentages. What is 100% persons? One is the 100% amount.
Yes.
As per the chart which they have produced, the compensation has been fixed, the amount has been quantified, mentioned, and on the right hand column, paid and signature is there. So whatever was the compensation
I
fixed,
have not seen, my lord, my argument.
you better see it.
I see. My argument would be, my lord, that will not necessarily, my respectful submission, my lord, whether here the amount has been paid or not. In land acquisition paid, here whether the claimant is agreeable for that amount or
No, we
not.
are on, that is a separate thing. On fact, we want to know
Yes, Lord.
that whether whosoever has taken, he has taken the 100% of whatever he was
That I
entitled.
have.
It is there, the documents are there.
I'll
I
see.
can understand that not all of them had taken, only 80% had taken. And it was only 20% of persons who were yet to be
I will
paid.
see personally and see.
And those 80% who have taken, as per the records, it appears that whatever was their entitlement as per the land acquisition officer, they have taken that money.
I will sit and see. Without
ये
seeing,
सारे यहाँ पर
without
exhibits
seeing, I
हैं.
can't say.
You can just have a look at that.
Yes, please.
Blue folder that contains that blue folder which your ladyship has.
Yes, this one.
That contains one of the awards in the middle. That will perhaps help my son.
No, he would like to see this. बताते हैं क्या
That is,
देखना
I think, for the village Gari village.
Ah, 80%. My lord is saying 100%.
पैसा हम लोग 80%.
My lord is saying we have to see. We have to see. We can't see.
It is 8.
Just a minute. I'll just show it to you.
Can't see. I think coming from my lord, we have to
You just have a look at this. I'm just giving you one page. ये देखो, इस तरह से लिखा हुआ है सारे डॉक्यूमेंट्स पर. This is the amount quantified here, and then on the right hand side there is a signature, and it shows paid.
But one thing is there, Lord, how much amount actually they are entitled for?
That is, you see, whatever was their entitlement, that has been quantified, mentioned, and paid.
No, it is mentioned that 576
ऊपर top पे देखिए ना, ऊपर में column
amount
है.
to payable to each.
Yes, payable to each.
Payable to each.
तो वो amount लिखा है
Yes, Lord.
और right hand side में लिखा हुआ है. और आपके किसी भी एविडेंस में मुझे ऐसा नहीं मिला कि कोई भी बंदा ये बोल रहा है कि I have only taken 80% of my entitlement.
In some
No.
columns, signatures are missing also. When
तो वो missing जो हैं वो तो those persons होंगे 20% who are not claimed,
Yes, yes, absolutely.
who are not taken.
But
And the award of the arbitrator is
Though-
that they will tally and whatever is paid should be deducted and then amount is to be done.
though in my humble submission, Lord, it does not affect my case, but I am saying, Lord, kindly see these signatures.
That is
All-
not, you are
all-
not, you just tell me one evidence which say that I have taken only 80%
Yes,
of my amount.
I'll say tomorrow. I have not received the full amount. In
Full amount
evidence,
means
in
what? How
evidence,
much have you taken? 80%. From
Eight-
where do you get this 80%?
80% when the claim petition and the evidence it has come. It has come. I have read.
Not know 80% where, from where do you say
I'll-
80% taken? And then this document is certainly required to be seen, you just can't ignore it. This document is a part of the exhibit, you can't ignore it.
No, I'm not ignoring. I'm saying even accepting. Yeah, I have taken. I'm taking an argument against.
Yes,
me.
yes, I appreciate that. Irrespective of whatever be the percentage
Yes,
of
ma'am.
payment. In absence of an agreement, they were supposed to appoint an
I am
arbitrator.
not
One line,
agreeable to this amount.
that's right.
Yes, yes,
Okay, further tomorrow.
yes.
Tell me just how to
I'll
do.
show that 80%.
सबका appearance record करेंगे.
If you oblige.